All right, welcome back. News and Talk 1380 WAOK, the voice of the community. Call in 448-922-2703. Get you involved in the conversation. As we were talking about earlier, when it comes to the types of reforms that are needed, it's an all hands on deck situation. As we've seen with student loan reforms, if people keep beating the drum long enough, something will happen. As we saw with the overturning of Roe, and then the immediate executive action, people will respond. The government responds, but you have to keep the work going on that. And what we saw in the light of the Freedom Summer of 2020 were many calls for changes in our criminal legal system that have yet gone unheralded. But that does not mean that we stop working because there's still time and an opportunity if we make sure it is known the needs that need to be changed. So coming up in September, in just a few weeks, we have the fifth annual Race Matters Summit, sponsored by the National Coalition of Criminal Defense Lawyers. I'm a board member of the NACDL, and we're going to be down in Montgomery, Alabama on September 7th and 8th for a CLE summit. So for you lawyers out there who are listening, go to nacdl.org and you can register for the seminar, 12.5 general credit hours. Those are always good to have. But the conceptualization around it, that race matters in our criminal legal system. It affects what happens from initial contact with police on the street to the end of the case, and everything in between. As part of being effective advocates for our clients, criminal defense lawyers face the challenge of confronting the difficult issues of race. And so in the conversation we're going to be having in Montgomery, one of the opening plenaries that I'm going to be moderating, we're going to be discussing the current state of race in the criminal legal system. One of our panelists is going to be Miss Jumana Musa, who joins us now, as well as Professor Hassan Kwame Jeffries, who'll be joining us shortly. And also on the line, we have Senior Vice President of the Rainbow Push Coalition, Reverend and also attorney, Reverend Todd Geary. Reverend Geary, Miss Musa, thank you so much for joining us.
Good to be with you. Thank you very much for having us on.
Thank you guys so much. So, Jumana, I wanted to start with you. Can you kind of talk a little bit about your work with NACDL and why it's so important to address the issues of race as they currently percolate through our criminal legal system?
Absolutely. So currently at NACDL, I'm the director of our Fourth Amendment Center, where we focus very much exclusively really on the intersection between surveillance tools, technologies, and programs, and how they're affecting the way people are investigated, charged, and prosecuted. And that's significant for a couple of different reasons. First of all, the kinds of technologies that are being used are being deployed rapidly, often without notice. They don't get noticed even in court when someone is charged. They don't necessarily know that certain technologies or programs have been used against them. And so it's resulting in a kind of solidifying of the very racialized nature of policing in a way that could not have been imagined previously. So I'm going to go back and explain what that means. But before I get to that part, what we do at the Fourth Amendment Center is we create trainings, we create materials, and we actually assist people in litigating these issues and cases, because there is so much to keep track of. And for your average defense lawyer, whether they're a public defender or solo practitioner, there's no way to keep up on all the things that are happening and how to create effective challenges. Because right now we're dealing with, a set of rulings that really consider things like telephones that used to be attached to the wall, right? Versus the basically all-encompassing, all-knowing devices we all walk around with in our pockets. And so we have to think very differently about how people are investigated, how they're searched, how their devices are searched, et cetera. So just to give sort of a brief cap as to why this is really critically important in the context of race, part of what we've heard, and I think Professor Jeffries, when he comes on, is going to talk some to the history, so I don't want to sort of jump the gun on what he will have to say, or perhaps the Reverend is also going to discuss this, but I think it is no secret probably to your listeners that the project of policing in America has started as and has always been a project of policing Black bodies, policing Black families, policing Black communities, and keeping them in a particularized place in society, one that is controlled. And so in that context, in the context of, I know you were talking about Freedom Summer of 2020, where reforms were discussed, and I say that because in so many places just that discussion created backlash, but the reforms didn't come through. I think it's important to think about the fact that even the reforms being discussed as potentially viable are reforms that maybe people talked about 20, 30 years ago, but aren't even relevant to the situation we're living through right now. So the place where technology exacerbates these problems, and I'm going to wrap it up here, is in many ways, a lot of the companies that will develop these tools, these programs, will sell it as a race-neutral way of doing policing, whether it's deciding where to police or who might be a threat. The idea that because you put this into a computer, into an algorithm, which is basically just something that takes information, decides how to weight it, and then spits out an answer as to where or who you ought to police, that somehow makes it race neutral. And it is quite the opposite. It is very much perpetuating race in the criminal legal system, but even more concerningly, it is doing it at a rate that could have never been imagined in the past. And so what we're doing now is we're moving from an era of trying to unwind mass incarceration to really winding up mass criminalization, where people can be investigated in ways they never could and can be put into databases and drawn into different types of social structures that criminalize them. But it's really sort of anything that was done previously on steroids. So I'll be looking forward to discussing more about that. And I'm very interested in hearing the Reverend's perspectives as well.
Absolutely. And before we go to Reverend Geary, what you're talking about kind of very particularly piques the interest of people in Atlanta right now, because we're going through the Young Thug YSL drama that's going on currently, where part of the evidence being used against these individuals are their rap lyrics. And raising this question of, are rap lyrics art, or can they be used as evidence against you in a court of law? Are we to take what you say in a song as being a confession of sorts? Or when Johnny Cash says, "I once killed a man just to watch him bleed," is that just him using literary reference? What's your take on that before we move on from that point after the break?
Well, I will say I'm glad you brought that up, because it's a much bigger problem than it is for just Young Thug. Because when it comes to these kinds of statements that people might make online, in songs, in social media, they are absolutely being used to both draw people into what they call social network analysis and make decisions on whether or not somebody is a so-called gang member, but also used to prove intent in cases, intent to commit crimes, and also used in ways that aren't even culturally competent. So when I say that, I've known cases where someone is charged and they get charged as part of a conspiracy, which also may not sound strange to you, right? Once they're drawn into this larger social network analysis that decides they're a gang member, then they draw these big conspiracy charges to pull in, up to 120 or even more people based off of one shooting or one criminal act. And some of what comes up in these cases is social media posts. And I've even seen where a social media post where someone is literally posting a song lyric, not their own lyric, not a lyric they're singing, right? But posting a song lyric, which I remember the one in particular was, "Grab their guns, rob them of their chains," not citing it, because this is not a legal brief. Nobody usually puts a little footnote in and tells you who the lyric is from. But even things like that being used to criminalize people. And I think it's important to remember that it's not just a matter of should free speech be something that weighs into criminalization, but also the people who are assessing the criminality of these things are not even culturally competent in the culture, in the music, in the artistic realm in which it's being used.
I had a case out in Walton County, Georgia, and so they tried to claim that my client was a gang member based upon pictures of him wearing blue and white with a group of individuals on his Facebook page. So I had to put his mother on the stand to testify that they were at a family reunion, and that's why everybody had blue and white on. They weren't a gang. They were just the Williamses. And that is what happens. And as you say, there aren't culturally competent people addressing these issues and what it means for criminal defense. So I know when we start using big lawyer words and start talking about the Fourth Amendment and these things, this is why I like having people like you and Reverend Geary and Professor Jeffries on to break these things down. We'll be back after the break. And I'm going to go over to Reverend Geary. I want you to kind of talk about the role that lawyers have in this modern civil rights movement, Because a lot of people think that being a civil rights lawyer just means you show up, you have a press conference, and then you get a settlement out of the city. But there's a lot more that goes into it from that. So we're going to talk more about this after the break. Call in 404-892-2703. Get you involved in the conversation. News and Talk 1380 WAOK.